different boards and they function differently, had different compositions. I'm not trying to
about Perth.
Yes.
Just your view on Perth.
My view on Perth is, as I expressed before, it did have an oversight of Crown Perth. It came from a different background. Perth, my observations of Perth was very much alone in the Crown group in comparison to Crown Melbourne, because that was the central hub where Crown Resorts had come from. So my observations were that Crown Perth was always different. And I accept the fact that what you've said about the board meetings in terms of the duration and some of the formalisations, but it did to me have a level of difference.
And what was that level of difference in your view?
Well, certainly it didn't have that same relationship with Crown Resorts because the directors on the board, the independent directors, weren't Crown Resorts directors, whereas in Melbourne they were all Crown Resorts directors during my time. Previous to that, they had independents. But during my time, as I recall, they were all Crown Resorts directors.
So the key is, would I be fair to say the primary difference being the composition of the board?
Yes, I'd agree with that. The actual nature of the discussions that took place were not too dissimilar in the context of, as you articulated earlier on in the day, about discussions pertaining to finance, the CEO's report. So the structure and the agenda items were not too dissimilar.
Okay. All right. Can I want to now move to a more specific aspect of risk management and AML and the CTF framework for which you were responsible. And can I just start by putting to you some propositions, I think summarise the position so that we can move to some more sort of detailed analysis of some of the things in a moment. So a reporting entity under the AML-CTF Act, you know what I'm talking about there, the Commonwealth legislation, is obliged to submit threshold transaction reports or TTRs.
Yes.
And that is when physical currency is received or transferred more than $10,000.
Yes.
There's also a requirement to submit something known as a suspicious matter report.
Yes.
And there's no sort of definition of suspicious matter per se, but in simple terms, the Act requires a reporting entity to provide reports of unusual behaviour or transactions where there are reasonable grounds to suspect that a customer or transaction is related to criminal activity, or there are reasonable grounds to suspect the customer is not who they claim to be.
Yes, that's
a fair assessment. There's also an obligation to report international fund transfer instructions, or IFTIs.
Yes.
There is a requirement to identify and verify your customer, known as Know Your Customer, or KYC, for customers who conduct foreign exchange transactions where the transaction involves an equivalent of $1,000 or more.
That's one reason why we have to, yes, why Crown had to.
And there's an annual requirement to submit a compliance report to AUSTRAC.
Yes.
All right, now, there are a number of different financial institutions that are reporting entities under the AML-CTF Act, correct?
Yes.
And casinos fall within one of the limbs.
They've got their own specific gambling services piece, as I recall.
That's what I meant to say. So there's specific provisions that relate to casinos. Now, is it your understanding, or I should ask you, was it your understanding that Burswood Nominees was a reporting entity under the AML-CTF Act?
Yes.
Was it your understanding, or what was your understanding with respect to Burswood Resort Management Limited?
It was not a reporting entity.
All right. Can I just ask you to explain that a little more, in that it employed everyone. You think there was some form of management agreement in place between it and Burswood Nominees, so the actual individuals carrying out all of the functions at the Burswood Casino would have been employees of that entity. In those circumstances, why was it not considered to be a reporting entity?
Because Burswood Nominees Limited was the licensee, the casino licensee, and it was the operator of the business. Burswood Resort Management Limited provided the employees for the purpose of Burswood Nominees Limited to carry out its functions as the casino licensee, and hence the reason Burswood Nominees Limited was a reporting entity providing the gambling services.
I see. So if, put it in legal terms, if it's been carried out through the agency of a third party, the principal remains the party responsible for the report. There's a reporting entity.
Yes, well, the reporting entity that holds the licence and is providing the services.
Okay, in that same context, do I take it that Burswood Limited was also not considered to be a reporting entity?
That's correct.
Okay, now in that framework I've just described, a suspicious matter report is one that requires an element of judgment on the part of the reporting entity.
Well, on the part of those who are lodging the suspicious matter reports, yes, on behalf of the reporting entity.
The people who are involved in performing the functions for the reporting entity.
Yes. And
in this instance, all those people were employed by Burswood Resort Management.
Yes.
Now, one of the requirements of the legislation is that the reporting entity has to have an AML CTF program.
Yes.
And it's divided into Part A and Part B.
Yes.
Now, what was your level of involvement starting in 2007 when the Act was introduced for the development of the AML CTF program for Crown Perth?
In short, the program was developed. Best way to describe it as a template by an external law firm on behalf of the Casinos Association, and the reason for that was this was new territory. Casinos hadn't confronted this program before. It had been in place, banks I think a bit before, but the Australian Casinos Association group together developed a program with input from the various casinos around, I think it was Australia and New Zealand casinos, to develop the template. And I was involved in a working group.
All right. So it began with some form of template document, and was it developed and amended to cater for Perth casinos' specific circumstances?
Yes, that's right.
All right. Now, that particular program evolved over time.
Yes.
Just for the purposes of identification of the relevant program, can I think there's a non-publication order on this document. No, there's not. So this is CRL.554.001.03. Now, you recall you gave some evidence to the Bergen inquiry, and part of the evidence you gave concerned identification of what was then Perth Casino AML CTF program.
Yes.
If we can ask you just to have a look at this document, which is version 17. You may need to scroll through it to satisfy yourself that it was the AML, the last Perth Casino AML CTF program.
On the face of the first few pages, it looks as the one that was relevant at the time.
Now, in 2019, there was a development of a joint AML CTF program across the Melbourne and Perth casinos.
That was a program that was developed from sort of mid to late 17 onwards, with a review of the whole of the framework. But it came to fruition in 19.
Right. Now, at the time you gave your evidence in the Bergen inquiry, had that been fully implemented?
No, it had not.
All right. And do you know if it had been fully implemented by the time you left in 2020?
I understand that it had been implemented, but not fully implemented. There was a range of steps to go through to fully implement the whole of the program supporting positions that were being developed. But I can't say for sure exactly what stage it was at.
How can you explain how the changes between the Perth specific program and the joint program were identified? What was the process by which you developed the joint program?
The Group General Manager spent considerable time understanding the details of the Melbourne framework, because my instructions to her at the time were review the frameworks, understand if there are any issues or opportunities to enhance it. That was the writing guidelines for her. She reviewed the Perth framework as well, including all the supporting structures around it, and then from that position developed the joint program, which was to be consistent across the properties, which included a range of other supporting measures which were going to enhance the AML framework. That was the process that was undertaken.
All right. Now, once you had settled on a version of the joint program, who made the decision to implement that across the two properties?
I might just add two more parts, if you don't mind. In terms of the process, a key element to the program, the transaction monitoring program, was reviewed by an external party, and the actual joint program was reviewed. We took legal advice on the joint program from a legal perspective as well. That was the process. It was then presented to initially the Crown Resorts Risk Committee. They had asked for it to be presented to them for comment, which occurred. It was then presented to the Crown Resorts Board for comment and review. It was then presented to both the Crown Melbourne Board and the Crown Perth Board for their review and comment and adoption if they agreed with it.
All right. So just so I understand this process, the general manager for AML CTF, which at the time was presumably began at least with Louise Lane.
Originally, it was Louise up until mid-19.
Okay, so under your supervision, prepared the joint program.
Yes.
It then went from an AML CTF committee of some kind, did it, to the ERCC?
It was considered by a number of people in the business. I can't recall whether a specific committee meeting was convened for it, but input was taken from a number of people across the business who had relevance to the AML framework. All right.
But its next port of call after your department was the Risk Management Committee for Crown Resorts Group.
Yes, that's correct. But as I recall, I briefed the CEO of Australian Resorts about it, and he was obviously well aware of the process that we were going through. It was a long and detailed process to analyse the frameworks and to get to this point. But it did ultimately end up in a paper being prepared, which is a framework paper, broader than just the program. The program was an important part of it, that went to the Crown Resorts Risk Committee to start with.
And from there went to the board of Crown Resorts?
Yes.
And then from Crown Resorts Board down to the two boards of the Crown Perth and Crown Melbourne?
Yes, that's correct. It might have also gone to the Crown Melbourne Compliance Committee, if I recall correctly, or Compliance or Risk Committee, one of the committees.
All right. So by the time it reached Crown Perth or the Burswood Limited Board, was it effectively set in stone?
No.
And what ways could a joint program have been changed independently in Perth and in Melbourne?
If there were issues, they could have been raised. There was nothing off limits. If there was an issue pertaining to something that Crown Perth or Crown Melbourne had specifically about it at the board level, they would have been considered and understood. And practically there were none. There was discussion about it, but there weren't any. They could have raised issues if they had issues.
Given that it was a joint program, though, does that mean ultimately it would have to have been settled between both locations to agree on a joint program.
That's correct.
Okay, and there was a commonality of executives across those two organisations, was there not?
There were a number of executives that were common, yes.
All right. Now, as part of the AML CTF program, there is a specific AML risk register, isn't there?
There's a risk register that's part of it, yes.
All right. Now, insofar as the programs were joint, was the risk register for Perth separate and distinct from that of Melbourne?
Historically, they were. For the joint program, there was a detailed review undertaken by the Group General Manager of AML, and we landed on one to cover both properties.
And is that because the operations of each location were sufficiently similar for the programs to be regarded as the same?
Sufficiently similar in the context of the issues that we believe Melbourne would confront would be the same kind of risk issues that Perth would confront. There were some nuances between the original transaction monitoring or the risk assessments between Perth and Melbourne, but our view was when we looked at them holistically, we could compress them and enhance them, and that was sufficient, or that would suffice for the task.
All right. Now, this is for illustrative purposes only. So I know that the programs have changed, but I wish to, and this one may be a subject of a non-publication, to show you a clearer, colour version of the Crown Perth AML CTF program, which I took you to earlier. It's CRL.533.001.3787. And if, I don't know if it's public or not, but it should, we take that to page 27 of the document. Can we orientate that? Yes, thank you. Right. Now, I don't know if this is not public, so I need to...
It's fine.
Is it? Okay. Now, this, the program we're referring to, the Crown Perth program, it was in place for some time prior to the the adoption of the joint program, correct?
Yes.
And this risk register that's referred to on this page was part of the Crown Perth program?
Yes, if that's the one that's attached to the AML program, yes.
Yeah, I just want to indicate or take you through, if you like, what information is being provided by this document. So you can see that it identifies in this page by table games, illustratively, a risk on the left in the left-hand column, and what the risk is, and then you've got a specific control in relation to it, and it goes through each risk in the same way.
Yes.
And if without taking through every one, not all of these are connected to, if you like, transactions involving cash or transactions involving money themselves. So some involve cash transactions, as in money received by the casino, but there are other typologies that relate to other activities in the casino. For example, there are some that deal with the way in which games are played and people playing games in a particular way that leads to an ability to launder money.
Yes, I agree with that.
So the controls in respect of, if you like, the activities on the casino floor, in general terms, involve surveillance, correct?
That's one of the controls, yes.
All right. And what other controls?
Without reading this, but off the top of my head, security, table games, staff generally. All the staff that are involved in designated services have training, and it's not just limited to what's articulated in the risk register. It's about general suspicion.
Yes.
And that's a control to have a wide range of staff trained.
All right. Now, I appreciate that any person involved in any activity in the casino that could lead to a risk of money laundering or terrorism financing has a requirement to be alert to that. But would it be fair to say that the units with the primary responsibility or the most contact with those areas was a unit known as the AML team?
Can I get you to repeat the question?
There was a unit known as the AML team.
Yes, I get that, but in terms of the contact...
Well, it had one of the primary responsibilities for dealing with the AML and CTF parts of the business.
They're a very important part to it, there is no doubt.
Yes.
But the departments are equally as important.
I'm coming to those. So, but I'm just looking at those that have, if you like, frontline responsibilities. So AML team would be one.
I wouldn't describe them as frontline. They're doing the transactions. They're not dealing with the customers.
No.
They have a different function.
They're monitoring, correct?
They're monitoring, in accordance with the transaction monitoring program and in accordance with the other obligations the AML team has got.
All right. Leave aside the expression of frontline. AML team is obviously involved in AML. Surveillance team?
Surveillance plays a role, yes.
Cage?
Cage, very important, yes.
So they're, and presumably the people operating the table games as well?
Yes, and machine staff as well.
Machine staff, all right. Are there any others who have that sort of direct contact?
Responsible gaming team.
The responsible gaming team have an AML CTF function?
Well, they're trained in AML CTF.
Oh, I see.
And they are engaging with customers on the floor observing, as the same as with security, who are on the floor observing customers and customers' behaviour all 24/7.
All right. Now, in terms of, I'm just trying to understand the structure of the way in which employees are informed of the AML CTF requirements. So there's the AML CTF program. Is that available to all staff?
It's available. I would be surprised if all staff are looking at it. They would rely heavily on training.
All right. Is the Perth casino, the casino manual is another source of information about AML CTF procedures?
It is. It's related, but the main AML procedures are focused through the program and then down through the standard operating procedures that the relevant departments are subject to.
So the I'll get to that. So standard operating procedures would be presumably the main document that an employee would rely on for information about the AML CTF.
Well, that would dictate how they do their job.
Yes.
And they are crafted in a way which captures the essence of compliance with AML and their awareness of AML-related matters.
All right. Now, if I could start with the cage, which is a colourful expression. What exactly is the cage in a casino?
Well, the cage is the area where chip exchanges, people can exchange their chips for cash after they have won. People go there to undertake transactions on, when you say an account, it's a patron account, it's not an account as in a bank account of sorts. Patron account which they can go and transact on. They can take gaming tickets that they've won there for payouts. They can go there to have their loyalty card, money put on their loyalty card for the purpose of gaming and machines. So the function is largely dealing with cash and chips through the cage.
All right. Now, who was there anyone in the area of Cage who reported directly to you?
For a period, I had responsibility for Cage for a couple of years, if I recall correctly. David Brown reported to me for a period.
And when did Mr. Brown stop reporting directly to you?
I can't recall.
All right. And after he stopped reporting to you, who was his direct report then?
I think it was Alan McGregor.
And Mr. McGregor's involved in the CFO function in Perth Casino.
He was CFO Australian Resorts.
Australian Resorts. Now, so far as the Cage is concerned, who is the most senior manager in that area before reporting to the CEO of Australian Resorts?
The CEO.
The most senior person
Well,
involved
there's
in Cage.
the general manager of Cage and Count, who's responsible for the operations of Cage and Count.
All right, and that was Mr. Brown, is that right?
It was, yes.
Okay, and are there other managerial positions involved in Cage and Count?
There are a number of shift managers, as I recall, and then there are supervisors, if I recall, again, who have managerial responsibilities as well.
All right, now, in terms of dealing here now with AML CTF matters, suspicious matter reports, who was responsible for identifying suspicious matters and making the reports in the Cage area?
In the Cage area, anyone.
So any cashier?
Anyone in the Cage, any staff member in the Cage could lodge a suspicious matter report.
All right.
So, could raise a suspicion.
Raise a suspicion.
Yes, and they could prepare the details of it. Ultimately, all suspicious matters would go to the AML team, who would look at them and ultimately lodge them.
I'm just trying to understand the process. So a cashier observes something that he or she considers to be suspicious.
Yes.
The next step that person takes is what?
They can liaise directly with the AML, a relevant AML person. They can liaise directly with their manager to escalate it for the purpose of understanding what the issue might be, and then a suspicious matter report can be generated from that detail.
So there is a process of evaluation of the matter before an AUSTRAC report is generated?
Well, the process was it would be raised, it would be understand what had happened, why do you have a suspicion, and then it would inevitably be lodged by the AML manager. It was very rare for one, in my experience, that I'm aware of, for them not to lodge a suspicion when an issue had arisen.
Okay. Was it open for a cashier, for example, to raise a suspicion with his or her manager, and then the decision as to whether a report would be made rest with the manager?
That's a possibility.
And the ultimate decision would be as to whether a report was made would sit with the Cage management.
Yes, but I just can't recall the exact process. But it never came to my attention that a departmental manager overrode a decision of a staff member in terms of a suspicious matter being raised.
That may be the case. I was just trying to understand the actual reporting structure, the way in which it was intended to operate.
Yeah.
So,
and look, my apologies, I just can't recall whether the report went to the departmental manager and the AML team at the same time, or whether it was direct to the general manager. I just can't recall.
all right. Now, who had responsibility for the supervision of the Cage supervisors and the Cage shift managers?
Through to the general manager of Cage and Count.
Mr. Brown again, is it?
That's the position, yes.
All right. Now, how frequently was the general manager of Cage on site at the casino?
In my experience with Mr. Brown, he spent a lot of time at the casino. definitely long office hours and often out of office hours.
Were there shifts though, or not?
Not for him. The shift managers, as the title indicates, were there. One of them was there 24/7. And Mr. Brown would be there on occasion outside office hours as well, if the business required.
And when he was not on site, who had responsibility for management of cage affairs then?
The shift manager.
All right. Now, after, I think you've already answered this question, but I've forgotten the answer to it. After you ceased to be the direct report for security and surveillance, who was the person who had that responsibility?
Mr. Bossy.
Mr. Bossy. Now, insofar as going back to the cage is concerned, was there any process by which the day-to-day recording of transactions was checked by a manager within the cage area?
I'm unsure.
So, for what I mean by perhaps it's a hard question to answer in the abstract. It was the case that cashiers in the cage were responsible for recording amounts of cash, or either in physical currency or by transfer, that were allocated to a patron account. Correct?
Yes.
And as part of their procedures, they were to record the receipt of that currency either into the psycho system, the system of accounting for the Perth Casino.
Yes.
So, in order to ensure that that activity was taking place in accordance with the standard operating procedures, was there a process of which you're aware by which a supervisor for the cashiers checked regularly to see that that process was being undertaken in accordance with the SOP?
I'm unsure, sorry.
Is that something you would have expected to have been the subject of a internal audit?
I would internal audit audited cage and can on a periodic basis, and that would be something I would expect supervisors' duties to be looked at.
All right. So, is it your expectation that during an audit of the cage and count procedure, someone would audit the process by which either in terms of electronic transfers or physical currency was received by the casino and recorded in Psycho?
I don't know if I can be that specific, but my as best I can recollect, internal audit looked quite an amount of detail with cage operations, and that would have been, I would have thought, something that would be looked at.
Okay, so if there was such an audit, one would expect to find it in the records of Crown Perth.
Well, particularly for the transactions at the front desk. With respect to the transactions in terms of the electronic ones, I can't recall the supervisory capabilities or obligations. So,
all right. Now, in turning us now to the AML team, there are a number of reports that they receive through the Psycho system. Was it their obligation or their responsibility to review on a daily basis the receipt of funds into the casino, into the Perth casino?
Not all funds.
Did they receive a transaction report of funds received by the Perth casino?
It depends.
At the cage, I'm talking about.
It depends. They wouldn't be seeing reports on a daily basis of all funds received at the casino. They wouldn't be receiving reports of someone coming to the casino and depositing money on their account. There would be thresholds in terms of reports that were being prepared. There's thousands of transactions at the cage. What they did see was a telegraphic transfer listing report, which they saw, I believe it was daily, but some reports were daily, some were weekly, and others were periodic. But they certainly saw a telegraphic transfer listing report, a report generated from Psycho.
Okay, and what information does the telegraphic transfer listing report contain?
Well, that was designed to capture all deposits into electronic deposits into Crown's accounts.
Crown's accounts being its own bank account.
All of Crown's accounts, all of Crown Perth's bank accounts.
All right, and was there a system called iTrack as well?
There was.
What was iTrack?
iTrack's, as I recall, main function was predominant function originally was security and surveillance, incident management, and recording of data. And then I think I can't recall specifically, but iTrack then was expanded to include reporting on other areas. And I just can't recall specifically what was in iTrack outside of the security and surveillance piece.
All right, and was there something called a Psycho alert report?
Yes, there were various reports.
And what are they?
That's a report that's generated from Psycho set against certain parameters, as I recall.
So is that a report generated by the software itself?
I believe so.
So you set parameters, and the report is generated based on information that is entered into the Psycho system.
Yes, for example, you could have a Psycho alert report, for example, of a particular buy-in level or a particular turnover level. So you could say, I want to see every patron that has a turnover level of X dollars, and a report would be produced from Psycho on that information.
All right. Now, who within Crown Perth was responsible for AML CTF training?
The responsibility sat with me and my portfolio.
And there was an online training module?
There was.
In respect of the cage, is it correct to say that part of their training was receiving a briefing from cage management?
Yes, that was involved.
And would be right in thinking that briefing would be given by Mr. Brown?
Yes, but normally in conjunction with the AML officer, as I recall.
In conjunction with and who would the AML officer have been at that time?
Changed. There was a number of AML officers over the journey.
So an AML officer?
Historically, there was one AML officer, but that person changed.
I see. Is it correct to say there was only one AML officer at Crown Perth Casino?
Yes, until I think maybe 2016 or 17. I can't recall the year where there was a additional AML person allocated.
How many? Is just one?
Yes.
And so was that the position at the time you left the Crown Group? There were two AML officers at Perth.
It was supported by a group function. So there was a group analyst that had been appointed. There was a number of group roles that were being created to support both Perth and Melbourne. All
right. Now, just in terms of just going back for a moment, in terms of the analysis of the telegraphic transfer listing reports, was that a manual operation?
It was.
So did that require the AML officer or officers, once there was more than one, to physically go through the telegraphic transfer reports on a daily basis and look for signs of suspicious matters?
That's correct. There was a manual process for all of the reports, which would be delivered electronically, and you get the reports electronically, but they would look at them they'd look at them on the screen, or they would print them out and review them.
And do you have any appreciation of what sort of volume of information they needed to review each day?
No, I'm not sure.
All right. Now, who trained the cage management in the AML CTF area?
Well, there's a few levels of training. It's a bit broader than your question, so I apologise, but there was induction training, which always included for all staff on AML. There was the online training, which needed to be completed and refreshed every 2 years, I think. And then the AML officer at the time often spent a considerable amount of time with cage originally, and then on an ongoing basis, the AML officer would often present to cage staff on AML-related issues.
So there was an internal training of cage staff by an AML officer?
Yes, there was over a period of time.
Were there any occasions that you can recall when external AML CTF training was provided?
Digging my memory, but as I recall, we did have a former law enforcement officer come and speak with a number of departments, but that was some time ago, some considerable time ago. But otherwise, no.
All right. Was there a standard operating procedure for the surveillance team?
Yes, there were operating procedures for surveillance.
Was part of their responsibility to carry out surveillance and detect any signs of possible criminal behaviour on the casino footprint?
Yes, there was.
So would it be correct to say that within the responsibility for surveillance, one of their responsibilities would have been or is to be aware and on the lookout for money laundering activities?
Yes.
And money laundering activities that do not only involve the transfer of cash or transactions in the cage environment.
Yes.
So the kinds of money laundering that can take place during the playing of a game, for instance.
Yes.
And in what way, without giving away any secret information, is that surveillance undertaken? Is it by CCTV?
Yes, there's CCTV.
And do people walk the floor?
On occasion, surveillance would walk the floor, but not regularly.
And considering the possibility of criminals utilising gaming machines, for example, or table game playing to launder money, something that is at the forefront of the surveillance operation?
They are very much aware of it and alive to it.
And if a member of the surveillance team were to observe anything, I'll call it unusual behaviour that might involve a criminal activity, what was their obligation by way of reporting?
Well, they would investigate it, and the surveillance technology was to the point that their ability to track back and review carefully with clear footage was very strong by the time I left Crown. So they would investigate it, understand the issue, and escalate it if there was a concern.
How many members of the surveillance team were there at the time you left the Crown Group?
Possibly 20. Might be wrong.
And are they all on at one time, or is there a shift system?
No, there were shift systems.
All right. Now, in addition to the internal audit of the AML CTF program, was there any external audit undertaken by an independent party?
Yes, there was. There was an external audit undertaken by Ernst & Young some time ago.
Does 2010 sound about right to you?
Yes, that does.
And was there any other external audits undertaken after 2010 while you were the AML CTF compliance officer?
The only one that I can recall was a focused review of the transaction monitoring program in 2018 to assess it from an external perspective.
Is there any reason that you can recall why there was not another external audit in that 8-year period?
No, I can't recall any reason why.
Do you consider that to be a reasonable period between external audits of the AML CTF program?
No.
Did you raise at all with your management the need or a desire to undertake an external audit at an earlier point in time?
I don't recall.
Now, I think we mentioned earlier that there were some internal audits now undertaken biannually, I think you said, with respect to AML CTF.
It might have changed over the years, but my most recent recollection is it was a biannual audit that was undertaken.
Now, do you recall the extent to which the internal audits of the AML CTF program revealed non-compliances?
I don't recall, sorry.
Do you recall whether there were instances where the audit identified an absence of training?
Not specifically, sorry.
As you sit here today, does it ring a bell to you at all that there was some non-compliances involving the training of the AML CTF program?
Not really. Non-compliances, yes, I would expect them in all internal. Well, I'd be surprised if there weren't non-compliances generally with any internal report, but I can't recall specifically about absence of training.
All right. Is this be a convenient time?
Yes. Right, we'll come back at 3:10.
All rise.
Thank you, Mr. Preston. Please sit down. Mr. Futrell.
Please, Commission. Mr. Preston, let's return just briefly to one of the topics that we covered a little earlier, which concerned observations on the casino gaming floor by surveillance security. Can you step us through the process for reporting that internally? So if, let's say, a member of the security surveillance team identifies a suspicious activity, what is the next step that person should take?
Well, two separate teams.
Okay.
Starting with security. Security, if there is an issue that they observe, they will, if I recall, as a matter of process, contact surveillance for a couple of reasons, to assist them with identifying it, but also from a health and safety perspective, so they can have some overwatch. They will then log it into their various reports. If it's a material matter that needs attention immediately, they'll confront the patron, they'll engage with their line management and address it, and that will form part of their daily reports.
Okay, so can I stop you there then? I just
Sure.
want to ask you about two things you've mentioned. One is logging it in a report and a daily report. What sort of documentation is that?
I think it all goes into iTrack ultimately.
It ends up in iTrack. And is iTrack accessible as an electronic platform, is it?
Yes, it is.
And that can be interrogated for reports
Yes, it can.
that would identify the extent to which members of the security team are making reports of the kind you've just described.
It has all their reports on it.
And is there a feature with a daily report identifying any identification of unusual behaviour at the casino?
There is a daily report produced, yes.
All right, thank you. Now you're going to say something about surveillance?
Sorry, I hadn't finished that part of it though. Just to help,
Sorry.
that daily report would be circulated to a number of people, including the AML team, as I recall.
Right. Okay, so very well. That's security. Now what about surveillance?
That's security. Surveillance would often have a replica report, or they would add to the report if need be. They would add footage if required. But surveillance would have their own reports where they observed behaviours from their perspective that didn't involve security, and they would put that in their daily logs as well, and that would go into, they have their own arm of iTrack, which is surveillance specific, if I recall correctly. That information would be incorporated into the iTrack system as well.
And was there a process by which the manager of that area received some form of daily or weekly or monthly update on their reporting?
The manager's got it every day,
Every day?
as I understand it, yes.
And was that an automatically generated report from the iTrack system, was it?
Yes, it was.
Could I ask, I want to return, now, Mr. Preston, I do not expect you to remember this event. I want to ask you some questions about the document, again, for the purposes of identifying what records should exist. Could I ask that the witness be shown CRW.702.001.2374, and the pinpoint is 2445. This is an internal audit activity report for a board pack in 2014. And I just want you to confirm a couple of things. We a little earlier in your evidence, we dealt with the topic of internal audits and reporting, and you indicated there were some features of that. I just want to draw your attention to the top line of that report under the heading Audit Activity and Scope and Telegraphic Transfers.
Yes.
And then you'll see there's some issues identified. They're the non-compliances identified by the audit.
Yes.
There's a cause attributed to it. There's a risk implication. And then the area I'm interested in is under management response. And it indicates action plans have been agreed by management. Now, where where would we find the management, the action plans? I think earlier you said it would be in the report. It doesn't appear to be in the report. So where would they be?
This is a summary report for the board
Yes.
purposes. There's an internal audit activity report for each of these line items,
Yes.
which is a 5 to 20 page document,
Right.
which has great depth of the internal audit report undertaken. As I recall, the action plans were documented in those reports.
Okay. And in those reports, do they go on to deal with corrective actions, implementation, and timing?
That is part of the action plan, as I best I recall.
Okay. In the case of the board of Burswood Limited, in what way was information provided to it that each of the actions had been completed?
Generally speaking, because I can't recall this period specifically, but there was part of the internal audit report, certainly the more recent ones that I can recall, if I recall correctly, there was an articulation of status of, I think they ultimately turned into outstanding recommendations for implementation or action plans to be implemented. And then there was a articulation of numbers, not necessarily all the details of every action plan.
All right. Now, dealing specifically with AML and CTF as an example, because obviously it's an area of interest, to the best of your knowledge, where there were non-conformances identified either by way of audit or in the course of ordinary business, was there any process by way of disciplining employees involved in breaches?
Yes.
And what was that process?
There would be remedial action taken. As an example, if a cage cashier or a supervisor had not complied with their obligations, it was always raised to the attention of the AML officer. The AML officer would communicate with the cage management, and it would range from documented discussion through to retraining. It could lead to termination of employment.
And in the course of your time as with the Crown Group, can you recall an instance where it resulted in termination?
Not that I can recall.
And again, would there be records of this in the Crown Perth human resources area, would there, of the discipline?
There would be in human resources and or the departmental, and also in our compliance reporting piece for the compliance framework, there was a reflection of, in those instances, that remedial training had been undertaken or documented discussion had taken place or otherwise, as I recall.
I see. And who undertook the remedial training into AML area?
It generally, it was a combination of the AML officer and management in the cage, or sometimes possibly AML officer direct. I can't recall specifically.
Okay, thank you. Can I ask you some questions now about Riverbank Investments? It's a name I'm sure you're familiar with.
Yes.
Now, it was a subsidiary of Burswood Limited.
Yes.
And you were its company secretary between 2014 and 2020.
Yes.
Now, as I understand your evidence, its sole function was to operate bank accounts.
Hold a bank account, yes.
Hold a bank account, yeah. Now, it received funds from patrons who intended to gamble at the Perth casino.
Yes.
And it was, am I right in thinking it was operated to receive funds from patrons who resided overseas?
It could be overseas or local.
Overseas or local. It could be used, just talk about your knowledge here, by the way. So, to your knowledge, was it used by people domestically?
I believe there was some domestic funds deposited into Riverbank.
All right. Now, to your knowledge, was it operated sort of as part of it operates under different names, international commission business or VIP gaming or words of that description?
Yes, it received funds for that gaming activity.
All right, now I know this document deals with the South Bank investments material. You may have seen this document before. I'm going to ask you some questions about whether it's equally applicable to Riverbank. So is this document CRL.570.001.1789? Now, I know you were not involved in this communication. I just want to draw your attention to the third major paragraph. Now, I know you were not around at the time the accounts were set up originally for Riverbank Investments. But in terms of the way in which the accounts were operated, in the way in which they're operated here described for South Bank, was that the same to your understanding of the way they're operated for Riverbank Investments?
Same or similar, yes.
And so, although they may have been used from time to time for domestic players, was the main purpose for the accounts to facilitate the transfer of funds from overseas?
Yes. Or overseas players.
Overseas players, yes. Now, do you know which area of the Crown Group was responsible for opening the bank accounts in the name of Riverbank Investments?
No, I don't. Not specifically.
Which group within the Crown, which part of the Crown Group typically was responsible for opening and dealing with banks in respect of bank accounts?
The Treasury Department.
And was the Treasury Department located primarily in Melbourne?
Yes.
And who, if anyone, had responsibility for that function in Perth?
Opening and closing accounts.
Yes.
I don't think there was a responsibility in Perth for the opening and closing accounts. I might be wrong, but my understanding was it was always done through Treasury.
In Melbourne? So,
It's the resort's Treasury.
okay, but historically, obviously, Riverbank Investments was around longer than perhaps even South Bank Investments, I think.
No.
No? Okay.
No.
Now, as the course of your the information you've acquired as the AML-CTF officer, compliance officer for the Crown companies, have you become aware or are you familiar with informal banking systems?
Yes.
And they're sometimes referred to as money changers.
Yes.
And could you explain to the Commissioners your understanding of the way in which a money changer transaction operates to transfer funds between customers?
Between customers?
Yes, the money. How does a money changer in an informal arrangement work?
Well, generally speaking, it would be a customer depositing money with a money changer or remitter, and they would transfer the money to an intended location.
And that's typically, your understanding, it operates across borders?
Yes, typically.
And so, for example, a person may go to a money changer in Indonesia with Indonesian currency, and the money changer will arrange for the same customer to receive currency in Australia as Australian currency.
That's correct.
And is it the case, is your understanding that patrons might be attracted to use the services of money changers because the foreign exchange rates offered by them are sometimes lower than traditional financial institutions.
Yes.
And is it also the case that with respect to patrons of Crown Perth, a patron may have used a money changer because Crown Perth did not have a bank account in the currency of the patron? So, for example, Crown may have operated Australian dollar, US dollar, Hong Kong dollar accounts, Singapore dollar accounts, but not the currency for Indonesia, for example, or Malaysia.
Yes, I agree with that.
So a person who wished to provide front money to gamble in Perth from one of those jurisdictions may have been attracted to the use of a money changer.
Yes.
Now, plainly, the bank details for Riverbank Investments does not involve any description that associates it with the Perth Casino. It doesn't use Burswood, it doesn't use the name Crown. And is it your understanding that the account was established in that name in order to allow patrons to deposit funds with effectively Crown Perth without revealing that the funds were to be used for gambling?
As you indicate, Opposite Round was set up, so I can't speak specifically, but it was set up post South Bank when PBL purchased, and we can see what South Bank, the reasons for South Bank. I can't say for sure what Riverbank was, but that's clearly an outcome.
Yes.
In that the name, it's clearly an outcome in terms of it doesn't reference the casino.
So the patron is able to transfer funds by whatever means to an account in the name of Riverbank Investments historically, and if that transaction was shown to someone in their home jurisdiction, it would not indicate the transfer had taken place to Crown Perth.
That's correct.
Now, are you aware that gambling is not legal necessarily in all jurisdictions in the world?
Yes.
And are you aware that marketing of gambling in some places is also unlawful?
I'm more recently aware of that, yes.
Yes. And are you also aware that in some jurisdictions there are restrictions on the amount of currency that can be withdrawn from that country?
Yes.
They're often referred to as foreign exchange restrictions.
Yes.
Now, is it your understanding that money changers can be used as a means by which to circumvent foreign exchange restrictions?
That's a possibility, depending on the jurisdiction.
Or by way of example, a patron of Crown Perth who resides in a country that has these foreign exchange restrictions could utilise the services of a money changer to withdraw larger sums of money, or effectively transfer larger sums of money than is permitted under the home country's laws.
That's possible.
And is it your understanding that money changers are also known to have associations with organised criminal gangs?
I'm aware that is a vulnerability.
Well, in the same way that a money changer can be used for a legitimate purpose to move currency from one jurisdiction to the other, they can be used to move funds illegitimately.
That's a possibility, yes.
And would you accept that operating the Riverbanks account exposed Crown Perth to an increased risk that that account would be utilised by money changers for illegitimate purposes.
It has the potential for an impact on risk, yes.
It increases the risk, doesn't it?
I wouldn't say it decreases it, so it's potentially an increase in risk for the reasons you've described.
Well, it's more than a potential, isn't it? It's an actual increase in risk. The name is not associated with Crown Perth, so there's an element of non-disclosure of the true purpose of the funds.
Yes, I agree with that.
Now, is it the case that at your time that you were involved in Crown Perth's gaming activities, that management was not concerned about so much of the source of the funds, only that the funds made their way into the casino as front money?
I wouldn't necessarily say concerned with. I think the Crown's concern would be holistic.
All right. Now, just in terms of the actual responsibility for AUSTRAC reporting, would you accept that one way in which money changers may be used to launder money is to utilise what is known as structuring or smurfing or cuckoo smurfing, whatever you want to call it, where a large sum of money is broken up into smaller parcels.
Yes, I agree with that.
And the deposits are made into an account in smaller than the threshold transaction of 10,000.
Yes.
Now, during the course of your examination in Bergen, you were shown some accounts of Riverbank that revealed a number of multiple deposits of cash under $10,000, under the threshold limit. Now, I think you accept, and you probably accepted then, that breaking multiple transactions of that nature on any given day is an indication of money laundering.
Yes.
Now, it's also the case, isn't it, that as a matter of reporting obligation, that is to say, the reporting entity that has the obligation to report, that would rest with the bank, the financial institution, the bank that received the cash.
At the first stage, yes.
So is it your understanding that in the case of Riverbank's investments, for instance, if a money changer were to be utilised to transfer funds illegitimately in the way I've described, there should have been, or would be, a threshold transaction report prepared by the bank?
It depends on the volume. It depends on the amount of the transaction.
I'm sorry, you're quite right. I'll go back a step. I'm not talking about it's a suspicious matter report. The obligation would be on the financial institution that received the funds to make a suspicious matter report.
If they deemed it suspicious, yes.
If they consider it to be suspicious. Now, as I understand your evidence, because Riverbank Investments wasn't a reporting entity.
Correct.
But at the time that the patron's funds were to be identified patron to patron, if you like, the cage staff were required then to allocate the deposits into the Riverbank account to the patron account in the psycho system.
That's correct.
Now, as I understand it, your evidence, what you consider should have taken place is that a member of the cage staff should have individually indicated in psycho each individual deposit in the case of any transaction to a particular patron. So if there were 10 transactions of $9,000 in a day, each of those transactions should have been recorded in psycho as an individual deposit on that day.
Yes.
And do I also understand correctly your evidence to be that as a consequence of that, what should have then happened is the transaction report that AML team received should have received a report indicating there were 10 deposits under $10,000 on that day.
That's correct.
So if the system had operated in the way I've just described, is it your evidence that there should have been 2 potential sources of suspicious matter reports by Crown Perth? The first would have been by cage staff on identifying the multiple transactions under $10,000 on entry into the psycho system. That's one point. And the second would be when the telegraphic transfer report was reviewed by the AML staff.
They were the 2 opportunities to observe transactions of that nature.
All right. Now, I understand that after you had given evidence on one particular day in the Bergen inquiry, an investigation was undertaken to some extent of transactions on the Riverbank Investments account.
As I recall, that's correct.
And as a consequence of that investigation, you wrote a letter to Austrac.
Yes.
Could I call up CRL.663.001.0001, please? Now, I think with the benefit of the description of how the system should have worked, I think perhaps the letter is written to someone who has perhaps that received understanding. If I could just draw your attention, or I could summarise it perhaps, and then you tell me if I'm right or wrong about this. When you undertook, was it you or someone else who undertook this review of the Riverbank account?
It was someone else. It wasn't me.
Who was it that undertook the review?
I think there were a number of people involved whilst I was still in the witness box. If I recall correctly, it involved the AML team broadly. Mr. Claude Murray was assisting, and the cage teams as well, if I'm not mistaken. They were all involved in understanding the issue.
Okay, now it was identified, as I understand your evidence, and I don't know if you did this yourself or this was reported to you by someone else. Instead of the individual transactions being recorded in psycho in the way in which you say they should have been, which is each deposit is recorded as a separate deposit, the cage staff, someone in the cage, at the time they allocated the funds to the patron account, they aggregated it. So in other words, using the example I gave earlier, instead of there being 10 individual deposits of 9,000, there was a single deposit of 90,000 recorded.
As I understand it, that's correct.
Now, is the consequence of that when the telegraphic transfer report was reviewed, or could have been reviewed by an AML team member, what they would have observed is a deposit of 90,000 on a given day?
That's correct.
And is it also the case that that would not result in a requirement for Crown Perth to make a threshold transaction report because the funds had already been received in cash by the financial institution before it was transferred to Crown Perth.
That's correct.
So the consequence of the aggregation then is that no one in the AML team was under any obligation to make a report to AUSTRAC, correct?
Well, not necessarily. If they deemed that suspicious, so if they looked at the...
Sorry, I'll finish that.
Sorry, apologies.
Obliged to make a threshold transaction report.
Either way, they wouldn't have to make one.
No, because there would be nothing in the telegraphic transfer report that would indicate anything suspicious.
But it wasn't cash. If they saw that, for example, your example of 10 nines, there was still no obligation for threshold transaction. The threshold transaction obligation sits, as you indicated, with the bank. So Crown's receiving electronic transfer of funds, not the threshold transaction, which is physical currency cash.
But just in terms of whether it would alert someone to the possibility of an account being used in an inappropriate way, without the aggregation, the effect of the aggregation is to cloak the separate transactions.
Indeed, I agree with that entirely.
Now, after you became aware of, can I characterise it as a misfire of the system in terms of the psycho allocation of the individual amounts to the patron account?
I'm happy for you to characterise it as misfire.
It shouldn't have happened. It should not have happened that way.
Correct.
Now, I appreciate this was in a period that was before the time you gave the evidence in the Bergen inquiry in 2020. Can you recall for what, and that the account, I know the account was closed, or we know the account was closed in December 2019. So in what time frame was the review undertaken at that time, the time this letter to AUSTRAC?
I don't recall, particularly as I saw a draft of the report, or the review, I should say, which was a time period. I saw a draft, but largely that matter was handed to others to manage and continue to explore, and then I had to go back and give further evidence
All right.
to the inquiry. But it was over a number of years that it was looked at, as I recall, the draft that I saw.
Okay. Was at this point in time, was the focus on the CBA, the Commonwealth Bank account?
I think it was.
Did the review include the ANZ account?
I can't recall whether it included an ANZ or a HSB. I can't recall, sorry.
Okay. But in any event, there was a review of at least one bank account or one of the bank accounts in that period that revealed this system failure.
Yes.
Now, can I ask you a question about the cage staff? Is there a high turnover of cage staff?
Not necessarily that I would describe that I'm aware of.
As of 2020, August 2020, were the same supervisors, shift supervisors in place as had been in place in, say, 2014?
No, there would have been changes.
Was the general manager of Cage and Count the same person?
I think so. However, Mr. Brown was leaving Perth for a new role with Crown.
Right. But at this time, and when I say at this time, I mean in the period up to the closure of the CBA account, Mr. Brown was the general manager of Cage and Count, was he not?
I believe so.
Now, who had direct responsibility for ensuring that the Cage procedures were properly followed?
would have been the general manager line for the operation of their department.
And by that do you mean Mr. Brown?
Yes.
And after it was discovered there had been a failure of the system, was any investigation undertaken into how that occurred at the time it occurred? In other words, why it was, in whatever time period that was relevant, members of the K staff were aggregating deposits?
I can't answer that, sorry. This piece of work was being managed by others at this stage. I was occupied with the Bergen.
All right, so you were not involved, and you were not aware of any investigation into the precise mechanism by which K staff came to aggregate funds?
That was part of the consideration that we were to explore. If I recall correctly, I haven't read this AUSTRAC letter for some period, or our letter to AUSTRAC for some period of time, but I did want to understand the root cause, which would necessarily include speaking to the relevant staff. But again, I was moved out of that.
All right. Now, given the potential for this to create an inability for the AML team to perform their function, would you regard it as a serious failing of the CAGE system?
It's a serious failing, full stop.
And in circumstances where there is a serious failing of this nature, would you expect there to have been some disciplinary proceedings taken against those responsible?
It's hard to answer when I am not aware of the review that was undertaken and the root causes and people's conduct, so it's very hard for me to say.
Well, one would expect, would you not, there to have been an internal investigation of a thorough nature, correct?
Yes.
And that those members of management, if any, responsible for any serious failing, disciplined.
If there was, yes.
And one would also expect there to have been retraining of K staff.
That would seem reasonable, at least.
And you'd expect that to take place immediately, wouldn't you?
This was going back in some considerable time. The years that I recall they were looking at was some many years ago. So to understand who was involved, there's quite a lengthy process to establish that firstly, and who might still be involved and still current employees.
Yes. But as of August 2020, Crown Perth continued to operate bank accounts, correct?
That's correct.
And although the name Riverbank Investments was not involved in those bank accounts, the same kind of transaction could take place on any bank account, couldn't it?
That's correct.
So if a overseas patron wished to use the services of a money changer to transfer funds into a Crown Perth account, the same process could be involved.
It could, but there were processes put in place immediately, I say immediately, very quickly, pertaining to all bank statements were to be provided to the AML team for review. So they weren't relying on the CAGE staff to input details into Psycho, which was an immediate step to prevent that weakness from continuing. Which is an important piece because that seemed to be where the breakdown was.
All right, but you've got 2 AML officers in Perth at the time, is that right?
Yes, and they were being supported by the group who were looking at these as well, as if I'm not mistaken.
The group being people in Melbourne?
Yes, performing the group roles, yes.
Coming back to my question about retraining then, to your knowledge, was there any instruction or retraining undertaken immediately with respect to CAGE staff as regards operating accounts at that time?
I'm not sure on the retraining. Again, I'm not trying to not answer the question, but I was taken out of a lot of these this activity from that point onwards because of the Bergen inquiry and preparing statements and the like. But I did meet with the relevant senior members of Cage, Legal, a group of maybe 15 people to express, to ask them about this issue and to express a very clear position from my perspective that this could no longer continue at all. And it was off the back of that, if I recall, that AML took custody of the bank accounts to review them, even although Cage continued to do their job, and was made abundantly clear that no such process of this nature could continue at all.
All right. Now, can I just take you to another document? You were taken to this document, I believe, during the Bergen inquiry and asked some questions about it. I just want to ask, I don't want to ask the same questions again, but I think you may be able to give an explanation for it. It's CRL.563.002.4035, and this, I believe, will be subject to non-publication.
It's redacted.
Is it redacted in its entirety?
Not in its.
I've got a one that's all coloured in yellow.
Yes, it is. It's redacted in the title.
Oh well, that's that then. Okay. Now, can I take you to your statement? And I do appreciate that many of these events are of some time ago. Now, this is to do with the question I wish to deal with now is the closure of Riverbank's accounts in 2014 by the ANZ Bank. You remember being asked some questions about that in Bergen?
Yes.
Inquiry, and you have indicated that in your statement that from review of documents you accept you attended a meeting in 2014?
I accept it, yes.
Yeah, but you don't have any independent recollection of doing so?
No, I don't.
I wish to show you some documents, if I may, that I'll ask to see if any of these might facilitate your memory being refreshed. The first is a document CRW.529.008.8581. Now, this may be one of the documents you're referring to having been shown that did not assist you. There's an email about halfway down the page from Mr. Nielsen to you, copied to Mr. Spence.
Yes.
Now, given Mr. Nielsen was the General Counsel of the Crown Resorts Group at the time, is that right?
Yes.
And you were the AML compliance officer for Crown Perth at that time, not Crown Melbourne.
Yes.
Correct. So, were you the most senior person within the Crown Resorts Group at that time with specific AML CTF knowledge?
It would have been myself and Deborah Tagoni, who was my equivalent in Melbourne.
All right. And the request for your assistance would be directed to you in your role as the AML CTF compliance officer for Perth, Crown Perth.
More than likely.
Could I ask if you could be shown the agenda, which is CRW.529.001.9086. And if you don't mind just taking a moment to read it and see if that helps to refresh your memory. I'll show you some more documents before I ask you some questions, Mr. Preston. Have you finished with that one?
Yes. I just need to pan up if that's okay.
Yes, you can just tell the operator what you'd like to do.
If I can just go up to... Yep, that's great, thank you. Yes, thanks. Yes.
Finish with that one. There's another one to come. CRW 529.001.9139. And for context for you, it's from Mr. Barton to a number of people, including you. And it's essentially forwarding an email from Mr. Birch, who appears to be someone from ANZ Bank, to him regarding the agenda.
Let me just get you thinking.
Then, if I could ask you to be shown CRW 529.
Sorry, I hadn't finished reading
Oh,
that.
sorry, my apologies. Didn't appreciate that.
Thank you.
CRW 529.001.9136. It's an email chain. The relevant part starts about halfway down the page where there's an email from Ms. Tagoni to you and others. And then below that, there's an email commencing, Dear Josh, Deb, Travis. And what I want to draw to attention is over the page, there's the and from Crown, we will have, the third bullet point, your name, leading the discussion, please, Josh.
Yes, I see that.
So there's another document, ANZ.334.002.0001, which is it's just a meeting maker. CRL.557.001.0815. Now, in the case of this document, I need to draw to your attention, I do not believe you were the recipient of it, but there is a passage on page 0815 where Ms Brown from the ANZ is writing to Travis and refers to her understanding from previous conversations. You'll see reference there, aggregation of deposits throughout the course of the day. And the last document I wish to take you to is CRL.557.001.0805. Again, it's an email chain, but the one in relevantly is from Mr. Costin to you amongst others, indicating the account will be closed. And in this respect, also wish to draw to your attention the paragraph beginning the closure of the accounts, Riverbank account was expected, and then the reference to can customers be advised by relevant people that multiple cash deposits, etc. Now, having reviewed those communications, are they some of the communications you have shown that referred to in your statement, or are these additional or new ones?
I believe they are a collection of maybe, I think all of them possibly, but I can't be sure of some that I saw during the Bergen inquiry.
All right. Now, is it your evidence to this commission that you have no recollection at all of the closure of the ANZ Riverbank Investments account in 2014?
Well, can we just arise to ask my learned friend in this area to direct the witness's attention to an independent recollection as opposed to a recollection because of other proceedings he's been involved in.
Yeah, and so try and put it in a temporal context.
All right. So I'm speaking now about, as you sit here today, giving evidence to this commission. Is it the case, I'm happy to use the word independent recollection, you have no independent recollection of the closure of the ANZ bank account in 2014?
I didn't have an independent recollection when this was put to me during the Bergen inquiry.
You did not then?
No, but obviously,
and now?
Obviously now with respect to these documents I've re-seen,
Yes.
I can see that they were closed.
All right. So you just to be clear, do you now have, and you know what I mean by independent recollection, you can remember that event, the closure of the ANZ account?
I can remember it I understand it happened. I have no independent recollection of it actually occurring at the time. And when I saw this information during the Bergen inquiry, I had no independent recollection of it then. It was only these documents that drew it to my attention.
All right. And is it also the case you were saying, your evidence is that you, whilst you accept from reading the documents you attended a meeting, you have no recollection at all of attending that meeting?
No, I do not.
Do you, having read that last email communication, do you have a recollection of the circumstances in which the CBA accounts were opened?
No, I do not.
To your knowledge, was there ever a direction given to, well, let's before I go to that question, ask you this. Who was responsible for advising customers of the existence, as in the BSB number and the account number of the Riverbank investment accounts?
As I understand it, would have been through the international operations team.
And who comprised the international operations team?
There was multiple people, but it was essentially those dealing with the ICB business.
All right. So if we look at this email, which is CR L.55.7.001.0805, the email is addressed from a Mr. Costin to
Yes.
various people. And Mr. Costin is described as the Treasury and Finance Manager, Crown Resorts Limited. Do you know if he's still employed in that position?
I don't know.
Was he, when you were last an employee of the Crown Group?
He was when I was there. Yes.
All right. And Mr. Travis Costin is someone who is located or works out of Melbourne. Is that right?
Yes.
Okay. Now he has sent this email to Mr. Nielsen, who was the General Counsel at the time.
Yes.
Was he involved in the international business?
Not directly.
Not directly, but he, like you, knew of it.
Yes.
And Deborah Tagoni
She was same capacity as myself, but for Melbourne.
in Melbourne. So she was the legal counsel in Melbourne.
Yes.
So again, she had a working knowledge, but was not directly involved in the ICB business.
Yes.
Roland Tillier,
Tyler.
Sorry.
He was in the ICB business.
Yes. Stephen Hancock.
He was, I think, General Manager of Cajun Count in Melbourne.
All right. Craig Spence, we know who he is. Vasula Kessel.
She was, at that time, Financial Controller for Crown Perth.
Of Crown Perth.
Yes.
Okay. And David Brown. He was Mr. Brown, we've spoken of earlier today,
Yes.
General Manager Cajun Count. So in each instance at least, there's the General Manager of Cajun Count has been provided with this communication.
Yes.
Is it your evidence that the General Manager of Cajun Count in both Melbourne and Perth form part of the international commission business?
No.
Were they recipients of this email? Why would they be receiving it?
Because it was about cash deposits into the accounts.
All right. So of those people, the only one who has direct responsibility for ICB is Mr. Tyler, is that right?
Yes.
So is it the case then, the person who would be responsible for informing customers in the ICB business of the bank details of the Riverbank Investments account was Mr. Tyler?
From that group primarily.
And who in his team would be responsible for passing on the instruction that cash deposits under 10,000 are not to be made?
I'm not sure who would have been in his team, sorry.
All right. Well, Mr. Brown was the recipient of this email.
Yes.
What, if any, steps were taken at Crown Perth to ensure that deposits were not made into the Riverbank account of less than $10,000?
I'm not sure.
Were any steps taken to your knowledge?
I'm not sure.
Did you undertake any process by which you investigated to see if that was the case, if deposits of less than $10,000 continue to be made?
I can't recall.
Now, it's the case, is it not, that Crown Perth did not, to your knowledge, undertake any investigation into the operation of the ANZ accounts after their closure?
In 2014?
In 2014 and not until 2020.
As I understand it. But I can't talk to 2014, sorry, but in the more recent period, I can't recall any review being undertaken.
Can you provide this Commission with any explanation for the reason that no one involved in the AML CTF program management for Crown Perth undertook an investigation into the operation of the ANZ account until the Bergen inquiry?
No, I can't.
To your knowledge, were the independent directors of the board of Burswood Limited informed of the closure of the ANZ bank account?
I wasn't on the board. I can't answer that. Sorry, but not to my knowledge.
Not to your knowledge. All right. Commissioners, would that be a convenient time?
Yes. Mr. Preston will resume at 10 a.m. tomorrow. Thank you. We'll adjourn to 10 a.m.
All right.